Aloha. Welcome to Take Charge of Your Money. I'm Daria Loy-Goto, the Complaints and Enforcement Officer with the Regulated Industries Complaints Office, a division of the Department of Commerce and Consumer Affairs. RICO is the enforcement arm for over 140,000 licensees that are with the Professional and Vocational Licensing Division of the DCCA. Today we'll be talking about Hawaii's lemon law and the State Certified Arbitration Program, or SCAP. We will be covering what is a lemon, what do you do if you have a lemon, what is the deadline, what do you have to prove, what is the process, and what happens at the arbitration. Some of this may sound complicated and involve a lot of attorney jargon, but we're going to try and boil it down so that it's clear for everyone. Remember, this only applies to new vehicles. Used vehicles are usually not eligible for SCAP. First, what is a lemon? A lemon is all of the following: a vehicle with a nonconformity, defect, or condition that is covered by warranty. The nonconformity, defect, or condition substantially impairs the vehicle's use, safety, or value. And that nonconformity, defect, or condition still exists after giving the manufacturer a reasonable opportunity to repair. If the vehicle is a lemon, the manufacturer should replace or repurchase it. So you're thinking, I've got a lemon, what do I do now? Read the Lemon Law Consumer Handbook for information and instructions. It's good to have a working knowledge of the details surrounding the possibility of owning a lemon. Make sure you take the vehicle in for repair each time the problem happens. Be sure that all examinations or repair attempts are documented. Keep all copies of your documents. If the problem was not fixed within a reasonable number of times, write to the manufacturer. This gives the manufacturer a chance to make things right without going through the SCAP process, and it gives you more documentation in your files to present at a potential hearing. What is the deadline? There are two important deadlines you need to keep in mind. One, the lemon law rights period, and two, the SCAP case initiation deadline. The repairs and notification to the manufacturer should happen within the lemon law rights period, which is within the term of the manufacturer's express warranty, the period ending 2 years after the date of the original delivery of the vehicle to a consumer, or the first 24,000 miles of operation, whichever occurs first. Let's say that again. First, you need to be in the warranty period. Then, the attempts to fix the problem must happen within the first 24 months of buying the new vehicle or the first 24,000 miles of buying a used vehicle. For the SCAP case initiation deadline, you need to file the complaint within 1 year after the lemon law rights period expires. Your case should be initiated by the State Certified Arbitration Program, or SCAP. This means you must submit your application and documents well before that deadline to make sure you qualify. You'll need all that paperwork you've been diligently putting aside, and you'll need to fill out some paperwork to file the complaint. What do you have to prove? You must prove that you have either a serious safety defect or a nonconformity covered under warranty that substantially impairs the use, safety, or value of the vehicle, and that you gave the manufacturer or authorized repair dealership a reasonable opportunity to repair. Now, what is a reasonable opportunity to repair? To prove reasonable opportunity to repair, the law gives 3 guidelines. 1. If you have a serious safety defect, you must show that the vehicle has been subject to exam or repair at least once, but the defect continued to exist and is likely to cause death or serious bodily injury if the vehicle is driven. 2. For a nonconformity that is not a serious safety defect, you must show that it has been subject to exam or repair at least 3 times and continued to exist. You must prove the nonconformity is a substantial impairment of the use, safety, or value of the vehicle. That means it renders it unfit, unreliable, or unsafe for warranted or normal use, or significantly diminishes the value of the vehicle. 3. For a vehicle that has been in repair for a lengthy period of time, You must show that it had been out of service by reason of repair for one or more nonconformities for a cumulative total of 30 or more business days during the lemon law rights period. Here are some statistics for you, a snapshot of 2 years. In 2013, there were only 12 lemon law cases filed with SCAP. 3 of the cases were settled without an arbitration hearing. 1 case was withdrawn by the owner. 8 of the cases went to arbitration. Of those, half of the decisions favored the consumer and half favored the manufacturer. In 2012, there were also 12 cases filed with SCAP. That year, 7 of the cases were settled without arbitration and 1 was withdrawn. Of the remaining 4 cases, 1 was decided in favor of the auto manufacturer. What is the process? Read the Lemon Law Consumer Handbook for information and instructions. I know what you're thinking. Why read the book? I'm watching this video right now. Well, like many great books, there's only so much content we can cram. Write to the manufacturer. For the address, see the Notice of Consumer Rights, which the dealer or manufacturer provided to you. Fill out the demand for arbitration form. Attach the repair orders, sales contract, relevant pages of the factory warranty, letter to the manufacturer, and application fee. Send the packet to SCAP. SCAP will contact you to confirm initiation of the case and to schedule the arbitration.
Something to remember, this is a self-help program. SCAP will provide an arbitrator for the hearing, but the state will not represent you. You'll need to present your own case.
What happens at the arbitration? The arbitrator explains the process and swears the parties in. Usually, the hearing happens in our RICO offices in a conference room. The consumer presents his or her case by explaining the repair history of the vehicle, providing more details on the documents that have been provided, and testifying about the existence and severity of the problems. The consumer may also have a witness testify about the problem or an expert witness who gives an opinion on the substantial impairment of the safety or value of the vehicle. The consumer will show the calculation of the expected refund, adding up the cash deposit or net trade-in value, all payments made to the lien holder, separate collateral charges paid for items such as tinting and incidental expenses such as towing costs. The mileage offset to be deducted will also be calculated. The manufacturer then presents its defenses. The manufacturer may argue there was not a reasonable opportunity to repair, the condition did not continue to exist, the condition is not a substantial impairment of the use, safety, or value of the vehicle, the alleged serious safety defect is not likely to cause death or serious bodily injury if the vehicle is driven. The cumulative business days of repair does not total up to 30 or more, or the condition is the result of abuse, neglect, or unauthorized modifications or alterations of the vehicle by the consumer. After the hearing is closed, the parties wait for the decision to be mailed to them. If the consumer wins and the manufacturer is ordered to repurchase the vehicle, the consumer must provide the lien holder account information so that payoff can be determined. The manufacturer typically must comply within 30 days. If binding arbitration was chosen, the decision is final. If non-binding arbitration was chosen, either party can appeal. An appeal is basically a brand new legal action in court.
That's a brief view of the lemon law process. We hope you feel more confident in understanding your rights when it comes to buying a new vehicle.
For more information, contact the RICO Consumer Resource Center at 808-587-4272 and ask for a copy of the Lemon Law Consumer Handbook. This information is also available on the RICO website.
On behalf of the DCCA, the Regulated Industries Complaints Office, and the State Certified Arbitration Program, I'm Daria Loy-Goto. Aloha.